Welcome back. The expert legal voice joining us today to advise you on your property-related disputes or dilemmas is Anand Patwardhan, Advocate, Bombay High Court. Mr. Patwardhan, thank you so much for joining us today. First question comes in from Manoj Makhija. Hi Manoj, how can we help you?
Actually, we wanted to transfer the property, for which we wanted to know what kind of stamp duty registration would be applicable. The inherited property basically between the two brothers.
Alright, so Manoj wrote in to us earlier and he's inheriting a property from his father, jointly owned with his brother. He wants to know what can be done if he wants to transfer it solely in favor of his brother.
This is an inherited property, and I think that means it must have come by either a will or by some family settlement. Let's say if it has come to him by will, then in that case, by the person who are the beneficiaries there, to whom that particular property has been bequeathed, that would be the basic ground on which they can decide to transfer the property. Let us say it has been bequeathed in the name of two brothers, and since he wants to have it transferred in the name of only one brother, then what could be the way he can have it transferred? One of them is a release deed, that's one way. Another way of doing it is gift deed. And a gift deed means admitting the fact that the two brothers have got equal share. So he will be relinquishing his half share in favor of his brother. And this being a gift between the blood relation, the stamp duty on this would be about 2% of the market value of his half share. So that's how it can be transferred, by way of a gift deed, or if there is some family arrangement, let us say some family settlement between the brothers, where this one property has to go to his elder brother and there is some other property which has to be given to the younger brother. That's how they can divide the property and get equal share in whatever they have inherited. In that case, they can very well draw up a family settlement deed. If there is a family settlement deed by which these properties are in this manner divided between the two brothers who are getting their shares, then in that case there is no stamp duty that would be required to be paid.
Alright, so in a gift deed you will have to pay some stamp duty.
In a gift deed, yes, there will be 2%.
2%.
Yes, on the market value of his half share.
Okay, alright. So Manoj, that's your answer. Moving on, we have another caller waiting on the line, Sanjeev Rao Katakam. Hi Sanjeev, how can we help you?
Hi everyone. Thank you for connecting me. I am a regular follower of your program and do follow all your episodes, which helps me in understanding the realty market. So I have actually a couple of questions regarding a residential apartment in Bangalore. I'm working in Wipro in Electronic City, and I have shortlisted a 3 BHK apartment in Purvankara West End near Kudlu Gate for consumption. It's not an investment. So, but I am taking it from the landowner share rather than from developer. So I had one question: that is there any difference or disadvantage if I buy from a landowner rather than from the developer? That is Purvankara in this case.
Okay. So safe to buy from the landowner versus the developer?
The landowner must have given development rights to the developer, and the developer must have constructed with rights to even sell. I'm little not sure as to how he would be buying from the landowner, unless there appears to be some kind of an arrangement between the builder and the landowner, where the landowner has been given certain apartments which he can sell as if he is the first purchaser or first seller, and in that case the landowner himself would come into the seat as a promoter.
Right.
Now there is possibility of such an arrangement where the builder, instead of paying him in cash for that particular development rights he has acquired, must have assigned or allotted certain flats to the landowner. In this case, it is likely to be treated as a second purchase. And in such situation, as far as the Consumer Protection Act is concerned, probably there would be a difficulty in case the apartment has any defects or in case he has to file any complaint with the Consumer Forum.
Right.
Otherwise, if he is buying from the landlord, and by that particular apartment that he is getting, it's a matter of best negotiation, whether the landlord is giving him a better price or whether it's the developer who's going to sell it to him at a better price, is for him to negotiate. As far as the landlord issue is concerned, whether he has the authority to sell those apartments, he needs to verify. If that is not there, then it would be treated as a second sale where the landlord has purchased his share and he is making a second sale to the purchaser, that is our collar here.
And on the quality of construction,
Then he will have difficulty because there is no privity of contract between the developer and the purchaser.
right.
So that would become a little difficult for him to take it up. It's a matter of negotiation and getting the best price at which he can
That
buy
will
that.
always work.
Yes, yes.
All right, so gift deeds, allotment letters and registration of societies, a number of issues that we discussed today and got Mr. Anand Patwardhan's expert legal advice. Thank you so much for joining us today.